This is,
Go ahead, just
okay. Variance 007-25, submitted by the Rensberger and Family Builders for the Grace Cottages subdivision to allow the use of one driveway entrance off Fisher Avenue for 3 homes. So we have testimony.
Can you read there should be the opening statement there.
Oh, well, all right.
Yeah, just read
Yeah,
this.
okay.
Yep.
All right. Good evening, ladies and gentlemen. Tonight, we have a public hearing on variance 007-25 submitted by C.E. Rensberger and Family Builders for the Grace Cottages subdivision located off Fisher Avenue. And this variance requests approval to allow the use of one driveway entrance off of Fisher for 3 lots of the subdivision. The application is made pursuant to the Poolesville zoning code, Appendix B, Section 10D 35, to authorize a variance, and Poolesville subdivision regulations, Section 26A2. The public hearing file, which is right here, has the following exhibits: an application for the variance, an affidavit of posting, the Board of Zoning Appeals notice of a public hearing mailed to adjoining and confronting property owners, a copy of the Frederick News Post with a notice of the hearing and the recommendation of the Poolesville Planning Commission. And any person wishing to do so may now testify after giving their name and address.
So what we've done previously is I'll just read the staff report, and then the applicant can give testimony, and then residents can speak. So this is the staff memo for the Board of Zoning Appeals on variance 007-25. This memo provides background and staff analysis of the applicant's request. So I'm also going to switch just for a second to have the property up there. The applicant, Rensberger and Family Builder, requests a variance from the subdivision regulations section 26A2, lot design, due to the Maryland State Highway Administration's denial of a driveway access on State Route 107. And so I'm going to just scoot to the next one. So this is the State Highway Administration denied having 2 driveways on the property that have access to Fisher Avenue, okay? And it's the one further down, if you're looking, or at the top of the image here, that was denied. The other one is the one that remains. So under the subdivision regulation 26A2, the Planning Commission may approve not more than 2 lots on a private driveway or private right-of-way, provided that proper showing is made that such access is adequate to serve the lots for emergency vehicles and for the installation of public utilities, is accessible for other public services, and is not detrimental to the future subdivision of adjacent land. Further, under the code, the Board of Zoning Appeals has to consider the following in granting a variance: to authorize upon appeal in specific cases such variances from the terms of this ordinance as will not be contrary to the public interest, where owing to special conditions particular to the property, the enforcement of the subdivision of this ordinance will result in a hardship and an injustice. To justify the granting of such a variance, the board must find that the hardship which the petitioner will suffer under the general provision of the ordinance can be alleviated without affecting the general purpose and intent of this ordinance, and the granting thereof will not be detrimental to the best interests of the community as a whole. The Planning Commission recommendation. The applicant appeared before the Planning Commission and gave testimony on June 11th, 2025. Planning Commission voted to recommend approval of the variance, which is discussed next. Staff analysis. When the preliminary plan for Grace Cottages was approved, there were two driveway entrances, one connecting lots 1 and 3, and the second connecting lot 2 on Fisher Avenue. When the applicant went to install these driveways, Maryland denied access to Fisher Avenue for the driveway from Lot 2, which is the one that we talk about there, and you can see there as well. The state gave two factors for its decision. First, the state determined that the driveway, meaning from Lot 2, did not meet the required site distance safety standards due to the curve of Fisher Avenue as you sort of go to the east of the property. Second, the state stated that SHA will not permit access from State Road if there is an alternative, if there is an available alternative from the less active local road. So what they mean, what the state means in that context, is that the other driveway counts as that local road with less activity, which, as I said, in their view, the driveway connecting lots 1 and 3 provides. The town confirmed these findings directly with SHA. The applicant has provided a solution by adding 2 pull-offs, which we'll talk about here, right up here, and to the remaining driveway. The town engineer has reviewed this, and has found it acceptable to the town. The Planning Commission reviewed the application and discussed the variance. The result of that discussion was the Planning Commission's recommending the approval of the variance. Staff recommendation: the staff concurs with the Planning Commission's recommendation for approval. And that concludes my staff report, and if you have any questions, let us know.
Questions?
Nope.
I'm just curious, why? I'm sorry. It seems like the curve is more on this side.
It is.
So why is that one? an
Because
issue?
they don't want, because they were concerned about the distance between the two driveways.
Oh, I see, versus the,
Yeah.
okay,
Yeah.
got it. Thank you.
That's traffic division.
Okay.
So that one driveway will serve all 3 lots?
Yeah, and there would be, from our understanding, and Joel can speak to this, there would be access to their garages from those pull-offs.
Where the red is?
What, sorry, yeah, where the red is.
Where those two reds are
They go
pull
straight
off.
to the garage.
Yeah.
No, they're just pull offs.
Okay.
So that in case somebody's coming in, there's, or going out, there's a place for the cars to maneuver around.
Yeah,
Okay.
and they have,
Driveway's 12-foot wide driveway.
yeah.
Okay, we have any testimony?
We do.
If you could give us your name and address and,
Sure. My name is Joel Rensberger, 1 South Main Street, Woodsboro, Maryland. I'm the small business owner, C.E. Rensberger and family. That was my great-grandfather. Good evening, Chairman and members of the commission, or the board. Thank you, Mr. Andreg. Thank you, Mr. Strong. Everything that they've presented is true. We went to construct the previously approved 2-driveway approach, but then State Highway indeed said no, and it's counterintuitive. We wondered. It took me a long time to understand why, but with the analysis that was done by the surveyor, it's actually safer if all 3 families go in and out there. So we have no objection to the state's request, and so if this is Fisher, then the driveways will come up here, and I'd like to have the houses, because it's a historic town, I'd like to have the driveways, get the asphalt sort of out of the way, and have the dwellings and sidewalk look a little more traditional, I guess, and sort of mute the garage, and then the larger lot is back here, like always planned. And I'm happy to take any questions that you might have.
questions?
there's no real choice in this, right? I mean, the state is requiring it, and other than not building on the lots.
Right.
This is, if you're going to build the lots, you have to have access, and this is where the state says you have access.
Exactly, and I think to confirm,
Correct. We met with the state today, and what they indicated was Maryland State Highways did their traffic look, and they determined that that location is where the driveway should be.
So if they're going to develop the property for 1 or 3 lots, that's where the driveway is going to go.
So why did we have to do this?
because no matter what, even if it is a state highway decision, we have to abide by our code. And so in cases where even another jurisdiction has made a change, we still have to go through the process to
okay.
confirm to our code.
Even-
So in this case,
State overrode what we,
what we had
Initially.
approved and what they had approved.
So that what happened was is they originally approved the
Two.
two driveways. Then when they started really looking at it really hard, they went, and that happens at the permitting process, through the permitting process. And when they looked at it real hard, they said, well, that's awful close to the other driveway. We want to condense it. There's probably, and I don't know this for sure, but also there's probably a impervious surface that they're considering too, because they have to conform with something called MS4. So they're always looking to reduce the amount of impervious surface.
okay.
But basically, because we have to conform,
Yeah.
this is the process we, as the town, have to go through.
Yep.
So I'm here as me, but I'm here
Right.
because the state sent me.
Right. Gotcha.
Well, okay, if there's no further discussion, we,
So we do have residents here, and if they would you like to provide any testimony?
Yes.
All right, so,
okay.
yeah, you have to come sit up here, so,
State your name and address.
yeah.
Excellent. Hello, everyone. We are Hare Krishnas, and we live right. Yes. Perfect. Thank you, John. I'm sorry.
Name and address for the record.
Yes, we are Hare Krishnas, and we live right across the developed lot that you're seeing on the screen. And our address is 19508 Fisher Avenue. So, so with respect to what John and Mr. Niles was mentioning about with respect to having a common driveway for 3 houses. Now, one of the, I did have this conversation with even John Strong, is when you have 3 houses, the amount of traffic that goes in and comes out to the state highway, and we live right across, it's going to be considerable. So we are asking the board to look into a couple of things that we as residents, what I understood from the memo which Niles was mentioning, it was mentioning all in terms of construction and everything. But in terms of day-to-day living and what the residents, and what impact it has for the residents living, I think that should also be considered into, like, when you're looking into having one driveway or multiple driveways. So the one with respect to is that I had, the question is with respect to the location. And today we had a representative come from the state highway, the MDOT, and he explained to us as to why it is there and where it is there. Now, this other thing that I would like to mention is as per the code, the current Poolesville code is a driveway can have only 2 houses, but right now we are having 3 houses. So with respect to that, I don't know where, I'm guessing most of you live still in Poolesville, and over the years that I have seen that I've been lived in Poolesville is most of the houses, they have something called small businesses, like either they're contractors or landscaping or something like that. Like, this is just an example. Landscaping and contractors is just an example. And then they have a whole bunch of cars just driving in and then driving out. And when something like that happens, there's going to be a lot of traffic. Currently, we have 2 upcoming projects that is going on. One is right across the town's office. Other one is the townhome. And the third one is right across the Spates Hill Drive, the lots which is
Yeah.
coming up, and this is the fourth one. So we have to take it, I am, like, as residents, because I live on that road, and I pull in and pull out, and I know the amount of traffic that we go through in every day. So, in short, we would like the houses that comes up, to have some kind of a variance built into, or some kind of a clause built into it. I don't know if I'm using the right word, variance, built into it so that, the houses that's going to be coming up would not have any kind of a business set up. In case if it have a business setup, it will be a lot of the last line which Mr. Niles mentioned is, the feel of the community. It's going to be lost because we're going to have a lot of, even if it is just 4 houses or 5 houses, it's just going to be neighborly, and I think that is going to be lost. So we would request, to come up with some kind of a clause that none of them should be a business oriented. I have seen folks, they are car mechanics, and they bring all their cars at 8 o'clock. They have their headlights on, and they're repairing the cars. Oh, it's my client's cars. They are my toys. This is this, and they're so proud of it. Good. But then with the lights reflecting onto the houses, and with so much of traffic in and going out, and that being a state highway, today, one of the state administrator was mentioning it is a 30 miles per hour. But having lived there for almost 5 years, believe me, nobody really drives at 30 miles per hour. And then if you have a driveway right across, and we have Zoom, a couple of construction vehicles and that and this, and big vehicles coming in, one is going to be a big safety hazard. And secondly, it's going to be, we're going to lose the community feel. That is what I can see. So I would, I'm requesting the town to really consider this. Maybe just put this out onto the entire town and see how they feel about it. Maybe in the newspapers, or maybe as a memo to the town. I know something has been done right from the June 11th meeting. There has been a board put up. But honestly, as who's been staying right across, I did not know what it was until something just came up. So, and when I dig deep and I just looked into it, and I don't want to specifically name which houses there, but then if you just drive on Fisher Avenue, after 7, you will see that some houses have 5 or 6 cars parked, right? And they are all mini businesses, either contractors or landscape or something like that. This is just an example. So I just want some kind of a clause to be put in there. Otherwise, it's just going to be, it's just going to be a nightmare with all of the glare coming into the houses, and we have the bedrooms up in there, and it's just, the whole lot of the community feel is going to be lost. So that is one of the things. And the second thing is, let me just pull it out.
Are you
Okay.
in the gray house?
Yes.
Okay.
Govardhan, that's right.
Yeah, okay. It's all coming together now.
Yes.
Okay.
So the first thing is we are looking at, one of the most important factor that I'm looking at is when I specifically mention in the clause being put, I'm looking at the congestion on the highway, as well as congestion going into the driveway, our driveway, as well as the driveway which is being proposed. And now this is also going to impact safety. That is what, I have seen. I have gone through the thing. The other thing is with respect to the parking orientation. Now, if you, Niles, can you just enlarge the map which is out there? I am just going to walk up right there because
It's on the screen right here,
Yeah,
too.
if you want point, there's another one there. That'll just be easier for you.
So, if you see this particular space.
You can face this side, I think.
8 by 20, all of this. seen over the years, like, even without the construction, when people have parties and things that way, and even otherwise, the cars, they are parked like this, with the headlights facing onto the road. And I have, and we need to have some kind of an audience built up so that, this one is going to be a no parking area or a no parking spot, wherein the cars are going to be parked like this, where the lights are going to be facing towards the road. If it's going to be facing towards the road, then we pulling it out of our driveway, we're going to have, even if it is one car, and if the lights are on to us, it's just going to be a big nuisance and a big safety issue. So we would make these, whatever the pull-out spaces that, that this area to be some kind of a wooded area or some kind of an ordinance built when you are thinking about approving 3 houses for a driveway. Now, let us even assume that our house is not going to have any kind of a business or anything for that matter, and each house is going to be having at the minimum nowadays 3 cars. So 3 times 3 is 9. So that's 10 cars pulling out in any given day at least a couple of times, and it's not like 8 to 5 kind of a job, kind of a thing. So you have to take that into consideration too. And then we would request to think about some kind of a privacy and a tree preservation line along the lines which I just pointed out, just to minimize disruption and improve safety. So that is one of the things. And even we are also thinking about having some trees, but then we would just like to give this. And then also, it is not mentioned anywhere in the plan, but we would like to see if they plan to have any kind of lights, but specifically with respect to outdoor lighting. What kind of outdoor lighting, where lamppost would be, where exactly it would be. You have something?
No. Continue.
Okay. Because it should not be, the lamppost or something, it should not be directly reflecting to our house, because we have, it's just, a few things like this would need to be. And then the other thing is, I have also been speaking to the county, let me pull out the names before I...
Niles, can I interrupt for just a minute? So, I hear everything you're saying, right? And you have a lot of concerns, which I get for someone who's living right across the street and for people who live in town. But tonight's hearing, the question is only
about this question of the driveway and whether it connects all
I'm
three.
not sure we could provide any relief.
Yeah.
Short of just rejecting the whole plan,
Right.
Which I don't.
Well, that's not
But
even on
have
the,
a basis
right.
for.
Right. But there's a couple of other things to mention. So, for example, for businesses, if the code specifically talks about businesses that have visits to it, so like if you had a doctor's office or something like that, there is a process where you have to go through in order for that to be approved. It's part of the special exception process. So that is trying to address the having a lot of vehicles come regularly. Now, I understand where there's a concern where somebody is an employee of a company and they park their commercial vehicle on their own property. That's different than those scenarios. But I just want to address up front that the code does directly deal with if you have a lot of people coming to your property, you have to go through a special exception process in order to get that business approved. The question of lights and outdoor lighting, the county has specific standards about how bright outdoor lights can be and how far the light from an outdoor light gets to, because it's supposed to go only as far as the property line and things like that. That's just as a jurisdictional point. That's a point that is the county's purview.
Now, answering to Laura's and Ralph's question as to why we are discussing all this is, we're discussing here, from what I understand, as to why the 3 houses needs to be connected to, is it okay for 3 houses to be connected to a single driveway? And the planning commission or commission folks, they mentioned, yes, it can be. Okay, but if it can be, but then what about all these concerns which the residents have? And like tomorrow, like, self-employment, the code, et cetera, all that is in place. And now as a resident, I have to make an extra effort to make sure that it has been implemented. And based on the administration, it is going to be interpreted differently. And I have seen that over the years in Poolesville, where things are interpreted very differently. And even simple things as like cars. I'm going to park, hey, they're just my toys. Okay, but then your toys are causing a big nuisance. And then and then people are looking into the code book. Hey, where is this? Is there a word for toys? Oh, there's no word for toys. We cannot do anything. Okay, so just leave with it, And then if there is businesses that is happening, the value of our property is going to come down. So who would want to buy a house when, when you have 10 cars parked and then the lights are, out there? Would any of you would like to live in there? That's a question that I have as a resident. If you're considering 3 houses to have a single driveway, we need to make sure that certain clauses are built, so that the person who is actually coming in and buying in understands, hey, these are the clauses that is there for this house. Do I want this or not? So I think it is fair from an administrative perspective to give all the information upfront to the person who is actually wants to buy there. I think that's a fair thing. I think that's a fair ask for anybody.
And that's just where it gets to a jurisdictional question. The Board of Zoning Appeals only hears the cases that are before it and has to decide based on your testimony, which is important, but also the conditions under which the code operates. So the applicant has presented a specific code request, which comes from the State Highway Administration, and that's the question before it. What other conditions or things like that are put on is sort of a separate discussion. At least that's how I interpret it. Jay, did you want to say something here on this?
But then, I'm sorry to say this, we're just looking like this. But then, if this approval goes through, I did even speak to, and even John was there too, at the today's meeting. If this approval goes through, then the ball keeps rolling, and it'll go down to the state highway, and then it goes to the approval. And once it's approved, I'm people are just going to say, hey, this is approved. We're just doing as per the approved plans. So if you have anything, I'm going to be coming here, and then NICE is going to say, hey, this is not the jurisdiction, this is not the board. So I'm just going to be running in circles.
So I'm hearing a couple things. I think one is the ordinance itself, right, which has probably a conversation to have with the town, because right, it's a living document. There are different ways of doing zoning in different towns and cities and counties across the country. And so having different requirements, right, they can go in there. The other part is this specific development, and it's already you have preliminary plan approval, right? And so there's certain steps.
At record plat. It has gone through the entire zoning process, just so that you're aware there.
So this group doesn't have jurisdiction to add the conditions that you're talking about to this request. The only thing that this board is looking at is to approve or deny having one driveway instead of 2.
So could you let me know which board would approve to adding on the clause? Because I go down to the SDOT, the MDOT, for them, they said, hey, it is up to the town, because the town actually planned this.
But I think it might be past the time to do that.
So Jay, can you address some of these questions?
Sure. I've heard the testimony and the conditions. And so just to give you the board a little background is that, you have 2 functions. You usually hear variances and you hear special exceptions. Special exceptions are also called conditional uses. And when we hear those cases, conditional use with the word right in it, you can put conditions on those. But this isn't a conditional use. That's about the use of a property. This is a variance to the code as to whether to allow 1 driveway or 2 and the number of lots. So it is not typical that you attach conditions to variances. These are yes or no things. However, the first request, which is the business issue, As Niles explained, there is a specific process for someone who wants to use their house as an in-home business, because it's not zoned for business. So you couldn't put like a 7-Eleven there anyway. And if the town changed the zoning to allow that stuff, that would be a legislative act, and there's nothing you could do to stop that as a board. But as far as in-home businesses, there's a process that Niles outlined. And for you to ban someone to have access to that process would actually violate the due process of that person later. So, say that without lawyerese. If you said to this home, you cannot have a business, but yet the code says if you want to have a business, you have to go through the process and have a hearing on it, you would be denying them the due process rights. And so that would eventually be void anyway. So that's a real non-starter. The issues that were with like screening and things like that, unfortunately, your board can't put these conditions on. These types of things could have been addressed at the planning commission level when they were reviewing the site plan and the subdivision plan. They're the ones that deal with screening and setbacks and lights and all of those types of things. What typically happens in a meeting like this is, people bring out these concerns. There's certainly things you can work with as a developer saying, hey, Mr. Developer, can you do this? Can you not do this? But the problem of making this agreement right here on the fly is whatever you agree to may alter the permissions that you're getting from other review agencies and change them. So, for example, putting screening up along the road sounds great, but it's a state highway, and we already know what state highway wants to get involved with what happens on that. So just to say do it may not be something that you can do, because the planning commission is the group that usually does the interactions with the state highway. So I hope that kind of helps you. Unfortunately for the applicant and the neighboring property owner, this one is almost a yes or no. Either you're going to allow it or you're not going to allow it. That help, Niles?
Yes, that was perfect.
Thanks.
So, yeah, we're going to have to kick that one upstairs for the planning commission or the commissioners or somebody, because we don't have the authority to do anything about what concerns that you have raised.
I understand, when Jay and Niles came up and saying that, hey, that, any kind of a business for folks, they have to go through the application and stuff that way. But if you drive around Poolesville, there's something in the books and something in the reality. Now, what we're doing is we're just looking at the books and saying, this is what it's supposed to happen. No, in reality, there is something else. And if you're residents of Poolesville, you know what the reality is. And I am here, sitting as a resident, represent the reality, and I would, and say this is what it is. And and Jay was mentioning about hey, due process, etc., etc., etc. Yes, due process is the book. Mm-hmm. And if the book says if you have a concern, this is what it is. This thing. Now this board is going to say, hey, it is okay or not okay to have a driveway for 3 houses. But then what impact is it going to do? Who's going to be addressing it? Who's going to answer those questions? So, and if yes, then maybe we move this meeting, give it a thought, talk to whoever is. Honestly, I really don't know who is there in the town. Who's there in the town's office? What are the commissioners do? What is the chain of command? Zero knowledge I have. I just am making sure that as a resident of the town, my property value is not diminished by what happens there and not there. And most importantly, the safety of my property. I was actually telling the MDOT folks, whatever the property that is coming up there and whatever my property that is there, it's going to outlive most of us. So let's do the right thing, rather than residents trying to beat up each other. That's all I can think about. Yes, this is yes or no kind of a decision, and then lawyery terms and book terms and this thing. But book terms really don't really matter when it comes to reality. Mm-hmm. And that's all I'm just saying. I'm here. Mm-hmm. And if you as Board of Appeals feel that hey, this is something, then let's move it down. We will go back. We will gather all the information. I hope this is still like, a working democracy. Let's put it out to the town. Let's see, hey, this is what one of the residents have, like, concerns. Do anybody else have any further concerns? Maybe we can, like, maybe somebody will come up with a solution, maybe, like,
Really, all
or
we
honestly,
can do
like, the
is,
way I'm thinking is, we are all in the same team. But if you want to put us apart in different teams,
yeah, there's,
okay.
we would have to find something wrong with the driveway plan or something that would give us grounds to send it back to the planning commission. But the concerns you raise, yeah, sometimes the discussions at the planning commission are pretty wide-ranging and will include things like that, so.
So I think just to address sort of the two things is, one, that there's a process that we have to complete tonight, which is the variance process, and that's what their charge is. Your concerns and things like that, one of the things is talking to the builder and see if there's things that can be worked out to address issues like the lights and things like that. The third thing is to say is that always, reaching out to the commissioners, talking to them about how you feel, processes are done, how, conditions that can be put on. It's a little bit different because in this situation, we've already gone through that planning process. So let me just finish what I'm saying right here. So in terms of where we're at, we can have a forward-thinking discussion about all of the concerns that you have. And talking to the commissioners, talking to me, talking to Wade, this is what we can have a discussion on. For the purposes of tonight, why don't we get through this conversation about the variance, and then we can have further conversations on these other issues in a different forum, so that your concerns are addressed more broadly, okay? And we can talk about vehicles and different things that don't just affect this property, but affect the town as a whole.
Okay, now it's, I think, before the planning commission meeting on June 11th, I think I sent out an email asking as to what we are discussing during the planning commission. And you specifically mentioned the only thing that we are discussing is just only the driveway and nothing else.
Yes.
And then we're going to be having a separate meeting with the Board of Appeals where we're going to be discussing this in much details. So I thought this was the meeting that we're going to be discussing in further details. And now the Board of Appeals is saying, hey, no, it is a planning commissioner. And now the planning commissioner is going to come back to the board. So all that I'm doing is just back and forth and back and forth. And now you're saying this is a separate process. I know, I'm just trying to be very, with respect to the process, I did reach out to the town.
Yes.
And the town specifically mentioned to me that the planning commission just deals only with this, and it is up to the Board of Appeals. It's going to be a separate meeting. And now we come back here and saying, hey, we are going to give this a stamp of approval, but we are going to go back. And then tomorrow I'm just going to be like, hey, this has been approved.
Yeah.
So I just have to.
No, I want to make very clear, if I didn't make myself clear before, I apologize.
Then,
But you're-
this is too late now. June 11th has already passed. I wish the planning commissioner was here,
Right,
who
and
would
that's,
that be?
and that's not when these other things would have been discussed either. This project and this thing was approved, the overall preliminary plan was approved in 2022. So what I'm saying is that the process, when they talk about the planning commission and the planning commission's process, they're talking about that, what we call the zoning process, the land planning process that we go through. That was completed a long time ago. The only reason why this variance is happening in these two meetings, the June 11th one and this one happened, is because of the state highways decision to deny the other driveway. Otherwise, this all would have gone through as that, per that plan that was approved in 2022.
So now, what I hear is, okay, the
Yeah.
planning commissioner has already said this, so this is set in stone, everything is there, so we cannot go back. And in case we need to go back, let's do it a separate process, and that process is not kind of J is, I think J is the lawyery terms here.
Yeah.
I think so, I don't know how that would, from a resident's perspective. A new development is coming, fine, but then the new development is hurting the current people who are staying here. And the Board of Appeals is saying, I'm just like, I hear two different things. Planning Commission, Board of Appeals, we can only do this, and the Planning Commission is saying we can only do this.
Yeah.
What do I do?
At this time. So I want to
Like,
address.
so at this time, then let's move this Board of Appeals to a different time, and then let's come back after the Planning Commissioner has heard whatever the concerns the residents have.
I'm using time in two different ways. Time in the process versus time. The time in the process, the only thing that they're discussing, the only thing that we are dealing with is this issue, because this is the only thing that can be addressed at this time. The process about the overall development, that was, as I said, concluded in 2022. That's what I mean by at this time. These are the only things they can discuss. So the other thing to just to mention is that I think what you talk about, new developments coming in and the process and the notification process of that, all of these developments, the one next door, the one next to CVS, and the ones here, have been in the process literally for years, and there's been meetings throughout that process. What you say, though, about notification and when new developments is a discussion that we've had internally about what do, not that there's a ton of new developments in the future, but if a new development happens or if a new thing is developed, what type of notification should happen in those cases? And I can't speak to things, 2022 was before I started with the town. I don't know everything that happened in with that process. But that's the key thing. So all those things, we can have a discussion. I think we can talk about the larger questions. But for right now,
I'm going to stop you for a moment here. Like, we are talking, you're talking a lot from a procedural standpoint. As a resident, with respect to the procedural standpoint, is something that, I understand Planning Commission, which is open to the public,
Yep.
and the Board of Appeals, which is open to the public.
Yep.
Now, can we have another Planning Commission, which is open to the public, wherein I bring out my concerns, like in public, out here? Because if it goes down to a separate meeting, okay, then we're going to come into, Jay was mentioning about with respect to the business process. Hey, we're going to be affecting the due process of the residents. But then what about the residents who are currently staying? You're affecting the due process by decreasing the value of their property.
Yeah.
So who's going to be answering to that? We're talking about due process of one party versus the other. So if you're talking about due process, everybody should be on the same platform.
yeah. No, I completely understand that. And what I would say to that is,
So now since you understand, how can we do
Yeah.
things in the right manner, with, in a public forum, so that not, I understand about a separate meeting in a public forum, because I feel that a public forum is much easier to convey, things rather than in a separate meeting. But if you
Yeah.
choose to, between now and the next public forum meeting, to have a separate meetings, I'm open to that.
of course. So here's my point. Here's two things I'll say. One, there's always opportunities to speak at our public meeting, at the commissioners' meeting, at the planning commission. You can come and speak on topics. Two, I'm always open to talk and conversations myself. There are commissioners who are willing to talk and would be open to having discussions. There are many ways you can address this. We have about 12 minutes before another meeting has to start. So for this meeting tonight, if we can conclude the question on the variance, you're welcome to come, anyone is welcome to come to a commissioners' meeting, to the planning commission at a future meeting, and we can talk about all of that. The commissioners' meetings, the next planning commission meeting will be in August.
Can we have specifically to this particular issue only? I am not asking something very much in general. Nice, you're mentioning everything that happens
Yeah.
very in general. With respect to this issue, can we say, John has something to say?
No. It's all good.
So, if we are going to be discussing this further, and if the Board of Appeals is making, if the Board of Appeals is going to say yes, it technically means you're going to be putting a stamp. And tomorrow when I come down to the town and ask for something else, hey, we have already stamped this. So I think, it can be, the can be kicked down the road.
So
So, I don't want to get into some kind of a situation like this. So even before, I'm requesting even before the stamp of approval is placed in, the residents being pulled in, the concerns are addressed. As I mentioned, this is you, if we are just looking like, hey, the Board of Appeals is just going to look only into this only, and this is what we're going to finish it off and this thing. If this is like, if this meeting is going longer, yes, like, and if we have a consensus, let's move it on to a different date.
Right. So, thank you for all of that. Why don't you, as the board, can discuss what you would like to do and how
Okay,
you'd like
is
to
there
proceed.
any further discussion among the board?
I think it's worth pointing out that, right, we are here because the request before us is initially in the plan, there were 2 driveways approved. The state came back after taking another look at it and said only 1 driveway
Yeah.
is safe. And we, as a town, are going to defer to what the state, we are
We have
required to.
We are required
defer
to
what the
because it is a
state-
state highway.
And because that is different than what our ordinance says, we are here as a board to consider a variance for that. So the choice for this board is, do we approve or deny 1 driveway for all 3 lots? Or do we deny 1 driveway for all 3 lots and essentially stop development of this property? In my mind, this property is residential. This group owns that, right? The choice, if you
Yes.
own your property, is how you're going to develop it. They're going to develop it for 3 homes, single-family homes, which is allowed under the ordinance. And to me, that seems like a reasonable use of the property. And to have a reasonable use, you have to have driveway access. So I would vote in favor of the single driveway.
What we need is a motion to approve the variance.
I move to approve the variance.
Second.
Second. All in favor?
I think we can do future impact assessment. So, because we cannot step back once the decision made. So if there is any concern, we can just do little bit more root cause analysis. Is it something really going to be impact the residents there? Or it is just assumptions and it's not what will be the reality?
Right.
Just future
I think
impact assessment should be, I think, because we should consider if someone or the majority of the neighbors have any concern.
And I think everything you brought up is good, and that's part of what the process of the subdivision process that was going through and completed in 2022 is about. That's why the meetings are public. That's why they go through and do that. So it's part, again, this goes back to sort of jurisdiction and yes, process, but the process is this way because of how things happen and how things have to go. So that is more of a consideration in the planning commission and in the zoning process than it is something here. And there's other issues that go into that, vesting rights and all this other stuff that is much more legal that is not really relevant to this. So that's the way that I would say that, but at the same time, I recognize where they're coming from. I recognize the whole conversation, but in terms of this issue, that's the most important thing, is the issue before you and what you can adjudicate.
Okay, so 3 in favor, 1 abstention. So the motion passes.
Yes.
So the variance is approved. Is there any old business?
No.
Any new business?
No. At this time, there are no current applications
Okay.
under advisement or anything like that.
In that event, we'll adjourn after we've made our decision here.
All right. All right. And so just so the applicant knows, the decision has to be reduced to writing. The town attorney
Yeah.
will write that and provide that to
The
you.
testimony that you've given, you are bound to. You may be questioned and held to that, so.
Absolutely. Our intention is nothing
new. They're already 3 separate lots. So I'd like to put a family on each. One of them's already sold. They don't run a home-based business. They've got a 1-year-old girl. We're talking to another couple, elderly couple, for the other one. They are retired. But I am happy to talk to you about other things that I can do that are on the property.
That's good.
What's probably good for you is probably good for them too. You know, so like, why not, right? A good idea is a good idea.
We certainly don't want to be dismissive. These concerns can be raised at any number of public meetings.
But about the tree, maybe we should.
You can speak and we can conclude it,
Hey,
so.
meeting's adjourned. Thank you
Okay.
very much.
Thank you very much.
Thank you very much.